Hey, good morning, everybody. It's Wednesday, it's Washington, and I'm almost home. At least I think I am. Today will be day whatever it is, 77, I think, of the USA versus Joseph Biggs et al. Case, the Proud Boys. The case will go to the jury today. We endured 2 days of closing arguments. Monday and Tuesday, the jury has been instructed on the law. They were sent home at about 5 o'clock. They're instructed to return at 9 a.m. They will be given the exhibits and then set off to find a verdict. Mr. Biggs and 4 of the other defendants face 9 counts each, including seditious conspiracy and 2 other forms of conspiracy, as well as a variety of counts involving violence. Today I woke up feeling like a truck ran over me and had a bitter night's sleep. There are always the closing arguments you want to give and the closing arguments you do give. And, I just felt like I had a big stage, didn't nail it. But I argued what I wanted to argue in spite of numerous government objections. We'll see what the jury does. I fully expect verdicts by the end of the week. When we began to pick this jury back, actually, I keep saying in January. It was actually, somebody reminded me the other day, it was actually in December. We began jury selection.
Every time we address this, you're like, oh, somebody reminded me it was actually 2022.
We began picking the jury in December 19th, and we began proceedings on the evidence, in this case, on January 13th. But when we picked the jury, we let them believe it could take a month or more. Well, we didn't let them know it could be a month or 3 months or 4 months more, So I got to believe they're anxious to go home. They appeared to be listening during parts of the closing argument. We'll see. The hard part of a trial lawyer's life is, you get a client accused of something, and if you're on the defense side in a criminal case, you study the law. You try to determine what it is the government's case will be. You select a defense of your own, decide whether your client will testify, put what witnesses you have on, and then do your best to push the case in the direction you want it to go. At the end, once you've pushed as hard as you can, and you've given your closing argument, it's out of your hands. And there's a tremendous sense of letdown, fear, and anxiety attendant to that. So my heart goes out to the Proud Boys and their supporters. One of the things I learned in the case is that they're not who you think they are if you're reading the media. And when I tried to address that in court yesterday, I drew one of a number of objections from the prosecutors that was sustained. We've jokingly ended these broadcasts, Mike and I, with my making an objection and it's overruled. Well, when the government makes one, it's always sustained. And there is a sense of bitterness on the defense side that we had not just 5 prosecutors at the defense table, but one in a black robe on the bench. But more about that later. So in any case, deliberations begin. Let's see what happens. There was a rumor yesterday that Mike Pence was in the House. The federal grand jury investigating Donald Trump, it sits on the 3rd floor of the Pretty Man courthouse. And we haven't talked about that enough. I mean, which part of irony is it that the Proud Boys, this male group that doesn't permit women as members, that they would be put on trial for their lives, as it were, in the Pretty Man courthouse in Washington, D.C. But on the 3rd floor, Pence came in, and it is rumored that he may have appeared before the grand jury investigating Donald Trump. And there are those who expect an indictment of Trump related to January 6th. We'll see. I could see cases that could be brought against him. I could see him defending on a number of grounds. It would certainly be historic.
We've certainly laid the groundwork for that here. I don't think shouldn't be any surprise to our regular viewers and listeners that, we've talked about there being 4 lawsuits that are ripe for Trump, and only one is ongoing at the moment. So,
well, and while we're on the topic of the Donald, Manhattan District Attorney Alvin Bragg yesterday, almost asked the court for a gag order. They're quick to say they didn't ask for a gag order. They don't want Trump. They don't want to silence Trump. They recognize his right to speak out about the prosecution against him. But they want to limit his access to discovery and they want to limit what he can say about what he reads as to his case. And so that seems to almost be a distinction without a difference. But let's talk about that. In criminal cases, obviously, as in any litigation prior to trial, parties have a right to discover certain things about one another's case. In civil cases, discovery rules are robust. You can send written requests for information called interrogatories, where your adversary is required to answer certain questions. You can send out requests for production where they're required to produce certain things. You can take depositions in civil cases where they're required, where not only adversaries but witnesses are required to answer questions under oath. And all of that information goes to helping you evaluate your adversary's case to learn how to defend or attack or present it at trial. There are also discovery rights in criminal cases, but the playing field is quite a bit different. Some states permit depositions in criminal cases. Florida is among them. I'm told by Florida lawyers that Florida is rethinking that. Connecticut and in the federal system, you can only take depositions in criminal cases with the court's permission, and getting that permission is very, very difficult. There is a fear that witnesses will be intimidated or otherwise made to feel uncomfortable about participating as witnesses in a case, especially those who are making the accusations, the alleged victims or persons who suffered the consequence of a crime. Manhattan.
So I guess just a really basic question: how is the court going to ensure that the media isn't reporting on information revealed in the criminal case?
Yeah, so what happens here, what they're seeking in the Trump case is a protective order over certain information. And this is not an uncommon move. In Connecticut, there was a famous case involving a gang murder. A guy named Russell Peeler was alleged to have shot and killed somebody in the course of a drug transaction. And his lawyer, during the course of that case, during the pendency of that case, a young boy who was a witness and his mother were gunned down and killed. And the state accused Peeler of that killing, and they determined that he got the identity and the name and address of these witnesses through discovery in his case, through reading police reports. So in Connecticut, when you receive criminal discovery, you are ordered not to share it or give it to your give copies of it to your defendant for fear that it'll fall into foul hands. If you share the information, they're not supposed to share that with the public at large. That's the gag order line that I think the Manhattan DA has crossed in seeking this. I think that if Mr. Trump has shown something, I don't think the court can say you can't talk about what you've seen. Now, the court may say you can't give Mr. Trump copies of these reports. Like, for example, in a case in gang violence, your client's in jail. You don't want to hand out police reports so they circulate around the prison system and maybe somebody gets whacked. But how are you going to keep a defendant from talking about the case against him? So I don't know what the judge will do. I mean, Judge Merchan is a tough guy. He's a smart guy. He certainly had his bluff called on gag orders before. It seems to me that this order is the equivalent of ordering Donald Trump not to speed. And the response there should be, I'm already under an obligation not to speed. So why a special order? To just increase the penalties over me for doing what I ordinarily do? Are you singling me out? I think if Manhattan District Attorney's Office has a concern about witness intimidation, witness tampering, obstruction of justice, they already have remedies to deal with that, and they should focus on those remedies, because Alvin, I think, is once again playing games with words. This is a gag order. He can say it's not, but it is. They understand that they have an obligation to share information with Trump's legal team. Trump's lawyers have an obligation to make Trump aware of what's in the state's possession. They cannot impose regulations on Trump's ability to speak, and he should fire him. He should fire him. He shouldn't fire him. He should. They should just reject the motion. The court should reject the motion for a protective order. And if Bragg and the Manhattan DA's office thinks that Trump's intimidating witnesses or interfering with justice, let them bring new charges on. While we're
I agree, and I bring this up on the screen because it starts to appear as though the structure of these potential charges in Georgia and perhaps in DC as well are going to beget a certain de facto speech blockade on President Trump during his run for president. What do you
mean by that?
Well, what the court does here in the Manhattan district court case is going to be precedent, whether you can use that in the traditional sense of the word, which obviously you cannot. But it's not as if these things are occurring in a vacuum. And if there are charges indeed brought forth in Georgia stemming from 2020 alleged election interference against Trump, there will be a similar effort on the ground there to limit the way that he communicates to his base about the ongoing issues. If similar thing occurs in DC and he's indicted pursuant to a grand jury that convenes there, I can certainly see that that Alvin Bragg's role here is ultimately to just sort of set up a blueprint for other courts to copy as we move into elections.
Maybe. I mean, certainly Trump looks like he's going to be if he's fighting for the presidency, he's also going to be fighting for his liberty at the same time. And I don't think that coincidence will be wasted on voters. Now, whether enough care to tip the results, I don't know. Certainly rabid or diehard Trump supporters will view these prosecutions and their timing as efforts to undermine his candidacy. His haters will say, no, it's justice under the law. In the middle, most of us will wonder, what the hell's going on here? Why are we prosecuting this guy again and again and again for old events on the eve of the election? It does raise questions in my mind. I think Georgia, it apparently is going to make an announcement about a case against Trump this summer. The United States Attorney's Office here in D.C. is sitting on potential charges against Trump related not just to Mar-a-Lago, but to January 6th. In each case, if Trump is charged, I think his instinct will be to make the charges public, to make them a cause célèbre, to talk at length about the nature of the allegations against them, and in his view, the political motivations behind those cases. In the federal courts here, he's going to have a problem. I saw a lot that stunned me in the Proud Boys trial. I saw the court just at the flick of a switch, without notice to the press, without notice to the public, just decide that we were going to discuss certain things under seal. So at any number of times in the transcripts, you'll see gaping holes where we've gone under seal to discuss something. We would object periodically, saying that Mr. Biggs and the other Proud Boys had a right to a speedy and a public trial. There is case law that suggests there are circumstances in which the court can close proceedings. I think Trump is going to run headlong into that. And I suspect that if he's charged in the federal court in Manhattan, there will be a gag order fight early in the litigation. I think that Judge Merchan sidestepped that in Manhattan. I don't know anything about what will occur in Georgia, nor do I know Georgia law. But I know here in D.C., the courts are very powerful, and they've taken a sort of casual view of the First Amendment and the public right of access to courts during a trial, and a defendant's right to a speedy and public trial. And I would hope that if Trump is charged in D.C., that he wages an aggressive fight against sealing orders in the criminal courts. The public's interest is getting done there. We're taking someone potentially and putting them in prison to serve the public's interest, and there should be no part of a criminal trial that is a secret proceeding. And I would contend that even includes the sharing of information. Defendants, no less than any other individual, have a right to the information about them. The public has a right to know how its funds are being expended. The defendants have an obligation to obey the law. Yeah, they may have broken it in some other way that the prosecution's trying to prove, but I don't think you can single out a man or a woman who's presumed innocent and say, you have now to obey the law. You now have to obey the speed limit, and if you don't, I'll charge you with contempt. There's already an independent obligation not to tamper with witnesses. There's already an independent obligation not to interfere with the administration of justice. When justice is done secretly, justice is denied, and public suspicion of gamesmanship increases. And I think that's what's going to happen in Manhattan if Bragg is successful in getting any kind of gag order on Trump. I think if Trump is charged in D.C., I'd encourage him to go right to the barricades and say this is bullshit. We don't need secret proceedings in the people's courts because at that point they become the functional equivalent of a star chamber. And I say this as a non-Trump supporter.
Well, yeah, and I think you made the remark to me before the stream that, if indeed Pence was in the building yesterday for other reasons, your closing argument wouldn't have done you any service if you were courting a client out of President Trump. But I do think that probably qualifies you better than the rest of the lot who would be motivated to represent him because of who he is. And we have a question in the Rumble chat. It's me again. Sai says, Trump doesn't ever seem to have good lawyers? Question mark on that. I think that the way we answer that can go several different ways, Norm, as I know you know. Good lawyers aren't necessarily, I think the outcome of a given legal proceeding isn't an indication in a vacuum of whether a person has a good lawyer or not. Certainly in these circumstances, it is quite difficult to ascertain whether the quality of legal representation is to blame for the lack of outcome for Trump. One could also say that the ability to forestall or elongate proceedings or to grind them out is the functional equivalent of having good legal representation. There's also the issue, Norm, that we can't ignore, the elephant in the room, in my opinion, which is the American Bar Association and the practice of law writ large is largely progressive and largely liberal. And we have seen time after time, not even necessarily to do with Trump, we have seen attorneys and firms send engagement letters and then retract them for fear of public pressure, fear of the board of directors or the members in interest of these larger firms. They don't want any sort of soil to the reputation, or they don't want the perception of being on the wrong side of things, which is a terrible affront to the practice of law and the rule of law, in my opinion.
Yeah, well, there is that. And I mean, I've heard from people who have offices here in D.C. that the District of Columbia Bar was very reluctant to take January 6 cases, and for the very reasons that you recite. People are passionate about this case. I mean, one of the court service officers made a point the other day of telling me that, this case is serious. He lost friends in 9/11. He knows what this is all about. And I'm thinking to myself, you don't know a goddamn thing about what this case is about if you're associating it with 9/11. But there was no point in arguing with him. But I did note the anger. The other thing, though, is high profile cases are high. Cases become high profile for reasons I don't fully understand. In the Trump case, I understand that he's the former president of the United States. Everybody's watching. The charges are significant. Celebrities draw the case. Other people get very interested in celebrity cases. We had the case of I'm just drawing a blank on the name. I'm having another senior moment. The case was just dropped. Rust, the actor.
Oh, Alec Baldwin.
Alec Baldwin. I mean, a routine accidental shooting on a movie set, and everybody's up in arms about it. I was Alec, and still am Alex Jones's lawyer, so that's a high-profile case that people took interest in, and many will say, well, you can't get, Alex Jones couldn't get good lawyers. I'm vain. I think I'm a good lawyer. I dragged those proceedings out. I did what I could with what I had to work with. But there's a saying among lawyers. And that is you can lead a client to the courthouse, but you can't make them think. You can advise a client about what the law is and make your recommendations. And when a client chooses the course of action they're going to take, then you have to defend it as best you can. Now, sometimes those decisions and discussions between lawyers and clients are such that a lawyer will be asked for permission to withdraw from a case on the theory that the client has become unreasonably difficult. That I don't respect that move among lawyers. I think the fact is that people come to lawyers because they're in difficulty, and then you ride the tiger, and you ride the tiger to the end, and sometimes the tiger eats you, and that's just the way it is. People come to court to resolve their disputes. If you're going to stand next to a controversial figure, that controversy will stick to you. So in Ray Donald Trump, what I've heard is that he's a cheapskate, that he shorts people, that he makes promises. I've heard a story from someone who had an office in his building in Manhattan, and Trump would work the offices. I've got a copyright case. Do you want the case? Here, think of the notoriety. I don't want notoriety. I want to get paid. But plenty of people will jump into cases for the name association. They'll take it as a lost leader, figuring it'll make the phone ring. I once had a discussion with a very famous person who wanted me, and this was several years ago when I was into my early 60s, wanted me to become part of this person's legal team. He said, this case will do you, this will make you, it'll make your reputation. And I said to the person, whatever reputation I have, I already have. I've done a career of lost leaders. I'm looking for leaders. And I hung up the phone. And so, I'm not going to attack Trump's lawyers. To the degree that he doesn't pay his bills, the reputation gets out. To the degree that he's fickle, tempestuous, and thinks he knows better than everybody else, well, welcome to the world of representing highly successful people who move mountains with the flick of a finger. That's what they're used to. If you're going to represent a headstrong, high-profile client, you need to have confidence in yourself. You need to know what you're about. You need to understand the client's objectives, and you need to put your ego second, because in the end, they are the master or the mistress of their own destiny, and you're there to deliver it. Sometimes the news you deliver is bad news, and it sticks to you. Now, Joe Tacopino, he's next. He's standing next to Trump. That's Trump's choice. Joe is effective in high-profile cases. He's not my cup of tea, but I say that in part because of professional jealousy. He's in a big city. I'm in a small town. So his phone rings with rappers and so forth. I just get ordinary murderers, and so woe is me. So I think you can't blame Trump for, you can't say Trump doesn't get good lawyers. He's got the world. His Rolodex is the world. He can reach out to anybody, and any lawyer will return his call.
That's right.
Some lawyers will take his case, and some will take it to get paid. Some will take it for vanity's sake. All will struggle to do well. But in the end, no lawyer can make a silk purse out of a sow's ear. And Donald Trump has brought a lot of his problems upon himself with a reckless personality, and a seeming love of controversy for controversy's sake. And so he's a perpetual, he's a fee generation machine for lawyers.
I was going to say, I mean, that was going to be my last point, is that, Trump isn't unsophisticated in this realm. I think I would consider him to be a very sophisticated purchaser of legal services. He's had to do so his entire career. I think it also takes a certain specific archetype of attorney that is capable of lifting the weight that Trump is going to put on the bar, so to speak. You can dream all day of being able to squat 350 for 10 reps. If you put it on the bar and your quads are little, you're not going to do it, right? Yeah. And that's not, that's not me saying that, that there can't be a David and Goliath situation, but Trump isn't trying to pay for a David, if that makes sense.
Nope. Well, we'll see what happens. So, I mean, I'm obviously watching with great interest to see what happens with him in the January 6th cases. Knowing those cases as well as I do now, I don't think they'll ever be able to prove that he engaged the Proud Boys or the Oath Keepers or anybody else to engage in seditious conspiracy. There simply wasn't any. That's a wet dream by prosecutors engaged in 2020 hindsight. But he could go down for mail or wire fraud, for continuing to raise enormous amounts of funds on the notion that the election was stolen, when he was given every reason to believe there was no proof of that by his advisors.
2 comments here. Freedom Lover says, how ironic. They say he doesn't pay his lawyers, all the while being sued for doing exactly that.
That's a great point. Yeah.
Lawyer Will says there's a whole book about Trump's legal cases over the years. It's called Plaintiff in Chief. He's been in more than 3,500 lawsuits.
3,500. Wow.
I don't even know that I've been practicing for 3,500 days.
No, well, that's a lot of law, and
wild, man.
I think I might want to read that book, or maybe I won't. Hey, let's pivot. What's going on, Bryan Kohberger's case? What's going on?
Well, it was reported, I think, a couple of days ago, April 24th. I'll put it on the screen here, that the surviving roommate of the slain victims in the Idaho murders, her name is Bethany Funke. She has been ordered to testify by the defense. They've issued a subpoena, and she's filed a motion to dismiss that subpoena norm. So this is I think this is notable for a couple of reasons. One, it might indicate that Kohberger's legal defense team has reason to believe that she has exculpatory evidence, in particular, perhaps about the chronology of events and the significant gap between, when these events were alleged to have occurred and then when police were called and dispatched. And then also there's a procedural issue embedded with the fact that perhaps she is not a resident of Idaho. And I don't know that that's a huge deal, but for purposes of the preliminary statement, that may be where you were going this morning when we briefly discussed that she might be able to avoid testifying in this part of the process, but she won't be able to avoid testifying in the larger trial.
Yeah, so the compulsory process clause of the Sixth Amendment gives a person a right to compel others to testify in their own defense. So Kohberger, indisputably, at least in my opinion, has a Sixth Amendment right to call whatever witnesses he and his lawyers think will assist them at the time of trial. It's not at all clear that he has that right at a preliminary hearing. A preliminary hearing is when a court determines whether the evidence is sufficient for a case to go to trial. And the usual standard for evaluating evidence in such hearings is whether the state's evidence is sufficient. And that is independent of whatever defenses a defendant puts on. And so Connecticut doesn't have preliminary hearings in the same way. We have what are called probable cause hearings, and they come to roughly the same thing. And you don't have a right to call witnesses at those hearings. And so Kohberger's legal team may have jumped the gun here. As to the interstate quality of this, there are ways to compel witnesses to attend trial from out of state, and these are Sixth Amendment reasons. Again, the Constitution is the supreme law of the land. The Sixth Amendment applies to everyone. And if you're sitting out of state and I've been charged with a crime and I need you, then what I have to do is I have to go to my home state, the state in which I'm being tried, and get an order requesting that an out-of-state witness be compelled to come to Connecticut. Once you get the in-state order, you go to the home state where your witness resides. You go to the local courthouse and you show your papers to that judge. If that judge believes there's good cause based on your papers to bring this person in, they'll have in the receiving state, the witness's state, they'll have what's called a show cause hearing. An order will be issued for that person to appear in his or her home court and say to show cause to that judge as to why they ought not to be compelled to come to my state to testify in my case. If they go to that show cause hearing and the judge orders them to appear, then they have to appear. And if they don't, they can be arrested. I had a case many years ago involving felony murder of a couple police officers or of a police officer and assault on a couple others. It involved a high-speed chase. My client was driving down a highway. He rammed a cop car. The car spun out of control. The officer died. He rammed a second car. The officer survived. There was a witness who was on the interstate that day and saw the collision between the second two cars. And in our view, she had something to say about what she observed that was helpful to the defense. We called her. She said she wasn't coming. So we went through the process. We went to a judge in Middletown, Connecticut, got the order. We went to a judge, I can't remember, in rural Rhode Island. We got an order for her to show cause, and she was so reluctant. Unfortunately for her, she was held in custody until she could be delivered to Connecticut as a witness. So, compulsory process is a real thing. I think Kohberger's defense team is right, to say that if this witness has exculpatory information, she will be required to testify. I just think this is too soon, and I don't know a lot about Kohberger's lawyer, and I don't know anything about Idaho law. So maybe Idaho permits you to call exculpatory witnesses at a preliminary hearing. If it does, the motion to quash by Ms. Funke should be denied. If it does not permit it, the motion to quash should be granted. And then she's on notice that she'll be required later. They're going to have to subpoena her all over again because subpoenas don't exist in a vacuum. They don't exist for perpetuity. They go stale at some point. And so they may have made a big mistake. If they're not going to want her, if they can't get her at a preliminary hearing, they've certainly placed her on notice that they're going to want her later, and she's got no obligation to wait around and be found. So if I'm Bethany Funke, I might be looking for a new name and a new place to live if I didn't want to avoid, or if I wanted to avoid that trial.
Interesting spin there. Yeah. Well, and of course, I don't know that, any show cause hearing on this issue would be granted in favor of the Kohberger defense team. She was a resident of the apartment that the
No, she's clearly got information that's going to be I mean, I think she's going to be compelled to testify at some point. The question is when. Yeah.
Absolutely. I agree. All right. Well, we have run up our time here, Norm. We've got a couple more things that I think we can probably slot for tomorrow, including the Olympia School District in Washington's decision to cut funding for 4th and 5th grade band and string classes. The quote that I pulled out of the Zoom audio was, tradition of excellence is exclusionary, which I think is just mind-boggling. Beautiful statement there. FIRE, the Foundation for Individual Rights and Expression, has sued, I believe it's the Tri-County Michigan School District for a violation of a couple of students' First Amendment protections. In particular, these students wore Let's Go Brandon hoodies to school on 2 different occasions, and both were required to take them off for violation of a student conduct policy. So we will see whether that has any merit. I tend to think that FIRE doesn't involve itself in cases and fact patterns that are capricious or somewhat frivolous. So I have
that's a clear winner for FIRE. I mean, we've gone through this in the Vietnam War in Tinker versus Des Moines School District, where young students were not permitted to wear black armbands in protest to the war, and the U.S. Supreme Court said that was a content-based restriction on their speech. So, FIRE is right. The Michigan School District will lose, and we will talk about it tomorrow.
Yes, we will. You can find us on Apple Podcasts, Spotify, Google Play, Overcast, etc. Please, please, please put a thumbs up on this video. It does help, whether you believe so or not. And I have a thing for thumbs. I like thumbs. Anyway, consider subscribing on Locals as well. Now that Norm is coming out of his post-trial blues, I can't wait to get back to thinking through some additional content opportunities for us and how to continue expanding law and legitimacy. Really enjoying what we're doing. I'm also enjoying our core group of viewers here that show up. And
we got to figure out how I can see those comments, because you have all the fun.
Well, here's one way we could do it. We could lobby Rumble to just incorporate with our streaming service, because we're on Twitter Live as well and YouTube Live. So Norm, we could just bring up the Rumble page on a separate browser for you if you find yourself savvy enough to just navigate between the browsers without getting distracted. You can very easily see all the comments, but I do what I can make sure that as many of those that will contribute to the conversation, and no offense to those of you that are just throwing stuff in that don't get read out, I do enjoy reading everything there. Anyway, I'm off to conquer some stuff for clients today. I know you're going to take a day and relax a little bit, Norm. Well earned. But we'll be back tomorrow morning.
Thanks. Talk to you all tomorrow. Bye.
Bye.